cannot see what must have been about 300 million people pop into this at the same time. Can you all hear me okay? I assume you can. Yes? Wonderful. So I'm Reagan Persaud, if you've not met me before, although I can see quite a few familiar faces already. So hello. And I can see some waving. Hi, Kate. So we'll make a start, guys. Thank you for coming to this afternoon session. We try and squeeze it into the hour, so it will hopefully only be 30 to 45 minutes. And it is a start and overview into how to draft threshold this afternoon. Have you all had the handout? Not if you have. Yes. If you haven't had the handout, I'll make sure Lee circulates after as well. So we'll go through the art, guidance and practice of drafting threshold. First of all, I hope you're all really impressed with my title. That took some time to think up, and I think that in itself is an achievement. But let's make a start then. I assume everyone works at a local authority, or if you don't work at a local authority, you want to understand about this anyway, because, for instance, you might do agency work. So in terms of learning objections, we'll understand the overview of the law on the issue of threshold, the importance of the evidence, looking at matters that may come up, and that is where we start to look more at the drafting part of it, understanding how to structure it, and then a final example with a good and a bad example of how to do that. Okay, so I won't go into the first law section because you all know section 1 and section 31 and section 38(2). It is the risk of significant harm versus reasonable grounds to believe criteria. So 38(2) is the interim threshold at start of proceedings, and then 31(1) and 2 is your threshold at the end of proceedings. Note, however, that what I haven't done in this PowerPoint is address the second part, which is the child being beyond parental control. And if that's something that you want a specific section on how to deal with and when it might arise, please just let me know. I think most of you can either have my email or you can email Lee. In any event, we will discuss it in overview as part of this. So we'll skip that first part. That's there more to make sure you all are aware of it and just to set up the background. But if we go to the case law part, which I think is more probably what you're dying to do. Now, when we look at threshold and drafting it, obviously you have the very difficult task as local authority solicitors of drafting the interim threshold, which I don't envy you on. I think that one is always the hardest one, particularly when all you've been sent is a section 7 report or bits of an email and you're asked to get the case ready to issue. And so that's quite difficult. I don't envy you on that. But in any event, whatever interim or final threshold has to address, I think the rules generally are the same across both, although we will go into the specifics of interim as well. So if we look first at the case law, I think you all will know that, of course, it's the local authority's duty to prove. We bring the case, he who asserts must prove, and the balance and the evidence we have to present to the court. But what Re B in particular talks about when it looks at drafting threshold is, and I've highlighted there, identify precisely as possible the nature of harm. Now, I raise these points and I hope that it will be helpful to you. First of all, that point is there because I'm sure many of you have drafted threshold where we've had things like, let me think of an example. The child's mother misuses alcohol and her final evidence will be, I only drink on weekends when the child's not in my care. And then the obvious argument will be, well, how does that impact on the child? Identify precisely as possible the nature of the harm. So what harm is the child suffering if the child's with someone else on the weekends? Sometimes then you have to be creative about it. And again, linked to harm must be attributable to a lack or likely lack of reasonable parental care. So that's what Re B is there for. And I raise that to the outset because I think when it comes to drafting a threshold document, I don't want to teach you to suck eggs. You all know how to do it in overview, but I think that is something that perhaps we miss sometimes because we start drafting and we think, oh, it must be substance misuse, but then we don't link it necessarily to the risk of harm. And I think marijuana is a good example of that, isn't it? Because you all know that there's case law that says marijuana use in itself is not a risk of harm. It's not a threshold. But I tend to find what you then need to delve beneath is what is the impact on the finances for the family? Has the child's needs been neglected as a result of the money being spent on marijuana? If the social worker had discussions with the parents where they've said, oh, it makes me slow, it makes me out of it. Well, that's your evidence, isn't it? That is your risk of harm, is that the use of marijuana makes the parents slower, not as responsive, and therefore the child is at risk of emotional harm. Something like that. Do you see what I mean? So sometimes that extra sentence is what you needed to link it. And that's what Baroness Hale at the time was talking about in Re B. Now, the second case I want to explore with you is Re M, and this is a bit older, but what it says there is when, in essence, when is the harm? When is the harm said to have happened, or the risk of harm? And of course, you all understand it's either the date that we apply, or it's the date the local authority first initiated the procedure for the protection of the child. And I'm sure I don't need to, again, tell local authority solicitors about why that's important. But if I give you an example of a horror story I had a case where the child had said, Daddy touched my bottom and it's really sore, and the child was bleeding. So what the local authority did was remove the child onto, what do they call it? A private family arrangement. How many of us have been told by our client department that they've done a private family arrangement, and the child now lives with grandmother for half a year whilst we investigate? Yes, we could do another session on private family arrangements if you like, guys. So in essence, I had that. And then what they did was they then placed the child back at home. 2 months later, the child then turned around and said, Daddy's also punched me in the stomach, and they issued proceedings on the punch. Now, as you can imagine, the judge was flabbergasted at the fact that we had a child who was possibly sexually abused, and we didn't issue proceedings, but we managed to do it on a punch to the stomach. And there was a huge legal argument as to whether or not the sexual abuse matter was even threshold, because what they'd done was they'd initiated protective measures, but then they put the child back at home right afterwards. And so you need to be conscious of that. If that ever comes up, that you might have to argue that one. And of course, advise your clients that you have to be careful in doing things like placing back at home. And Re-em is your case if you ever need that, to advise the client on, be careful because you might lose a threshold. Another one I had is when a local authority, who will remain unnamed, had an older brother and a younger brother in the house, and the younger brother said, my older brother pinned me down and buggered me, and that was his exact words, not mine. And the local authority split the family under a private family arrangement and left it 2.5 years before they approached council to say, should we issue this case, Reagan? I can see the horror looks on your faces. And then there was a great argument about, do we have threshold? Because it's been 2.5 years. So we always have to think about those things and advise the client. Re-em is your case if you ever need that. So let's move on in case law, relying on evidence since the relevant date. Now, when you draft threshold, obviously at the start of a case, you don't have all the evidence together. We do substance testing during proceedings. We instruct experts over bruising and broken bones, and we get the clarity we need. So never be afraid of relying on evidence or matters that arise during proceedings if it necessarily relates to what the situation was pre-proceedings. A good example of that is this. I have, and you will all have cases where children don't say anything when they're at home, and after they're removed at the interim stage, they then speak up. Daddy was touching me, Mommy hit me. Obviously, they're not talking about the time in foster care, they're talking about the time at home. And so it's still relevant evidence. Excuse me, guys. I almost sneezed. It's still relevant evidence, and it's still threshold evidence because it still dates back to the date before proceedings. And you will get the odd solicitor or counsel who goes, oh, well, they're talking about this during proceedings, so it doesn't count. It does. Re-G, that's your case. Again, Lady Justice Hale at this time talk about the fact that evidence that arises during proceedings, as long as it relates to incidents, pre-proceedings, you can admit it. What I do, just so you know from a stylistic perspective, if, for instance, a parent was misusing substances and we did the testing and we find out pre-proceedings they were misusing substances, and then there was another testing during proceedings and they've continued to use, I just put it under one big heading, substance misuse, talk about what happened before proceedings, and then put a couple of sentences to say, and it has continued during proceedings, which evidence is X, Y, Z. I don't think a judge is going to pick you up on that because, again, it's evidence that follows on from what the situation was like at home. They could technically try to argue it, but I think you'll get away with that personally. And it's stylistic, isn't it? But I normally include it. So that is that case if you ever need it. So in essence, what we started with, guys, just to bring you back, is to understand the law on threshold. So what we've covered is the different areas you can include in threshold, how wide your ambit is when drafting threshold. And in essence, the key things to look out for that I think a lot of solicitors and even counsel fall on, which is linking the actual worry, the concern, the harm, to the actual child and the likelihood of harm, and which child in particular, because of course it has to be specific to the children who are subject to these proceedings. I recently had a case where I made a mistake, and I did it, I say I made a mistake, I made an intentional mistake, let me put it like that. I had a dad who had sexually abused one of the children, and I purposely pleaded it along the lines of, by virtue of abusing X-child, all children are at risk of harm from father. Now, you will all understand why that was a finding that I would love for a court to make if you represent a local authority. And I was this close to getting it until it was pointed out by counsel for the father who came on last minute that we're not interested in every child, we're interested in these subject children. So I almost got it, not quite, almost. So, you know, again, it has to be linked to these children and the risk of harm to the specific subject children. Now let's move on to evidence. When it comes to drafting threshold, I think one of the areas we always fall down on is we plead things which we don't necessarily have the evidence for. And again, from a stylistic perspective, if you start the case, I certainly think you should put it at its highest in interim threshold. But then if you do, as the lawyer on the case, what you need to think about as you're drafting is, well, hold on a minute, do I have the evidence for this? If parents file their initial response and they deny this, what do I do? Am I stuffed? Am I going to need more evidence to support that? And so that's why I think it's important that we do look at what the guidance says on how you draft this and where the evidence slots into it. You will all no doubt be familiar with Sir James Mumby and Re A, which talks about the need for primary evidence. And if something is challenged, then the local authority is in difficulty unless they can call a witness to speak to it. Likewise, the deficiencies that were highlighted in relying on social worker chronologies and case records, the fact that they could be second, third hand hearsay, and sometimes the records can be inaccurate. Just so you know, this is a double-edged sword, and recently in cases where what I've been doing with local authorities is, for instance, where you have a case that a child has said something and the argument from the father or the mother is, oh, well, the child lies, look at the social care records on that. I stylistically have been relying on this case to go, well, look how inaccurate social care records are, Your Honour. I'm not so sure you can turn around and say that this child has lied. Look at what the case law says, which is really, really annoying, I'm sure, to my... But use it to your advantage. Can you all hear me? I think I went mute for a second there, but as long as you can still hear me. Yes. So you have to put forward primary evidence. And what in particular I say to people is, that is a Children Act compliant statement. That's what you need. Now pause there. Let me ask this question, and I appreciate you're all on mute, and there's 79 of you, and if all 79 answer, I'm going to be in real difficulty. Is a police statement primary evidence? Or is it hearsay? Anyone?
I might be wrong, but I'd say yes.
Right, okay. So it is a statement, and in police proceedings, what am I on about? Criminal proceedings is his primary evidence. But under the family procedure rules, you all know that the guidance says that we need Children Act compliant statements, don't we? And so whilst it can carry a certain amount of weight, it is actually hearsay evidence. It's an out-of-court statement that goes to the contents of it being true. And so what you need to do as the local authority solicitor is, if you rely on what an officer says to plead your threshold allegation, you need to contact the police force and copy out that statement into a Children Act statement and say, can you sign this? And then it becomes primary evidence. Primary evidence, as my general rule as counsel, is the Children Act statements. That is your primary evidence. So if anything you rely on is in a Section 7 report, in a, let me think of another example, a SIN meeting minute, a police record, a police statement, then you need to Yes, it is hearsay. Faith said that. Well done, Faith. Then you do need to get that in a Children Act statement. So when you draft, what I do as I draft is I think, oh, well, what am I relying on that? Worst case scenario, if parents deny it, can I prove it? Oh, I need some primary evidence. I need a Children Act statement. So I'll then email my solicitor to say, can you gather a statement from this person that addresses X, Y, Z? And that's how I do it as I go. And that way, if they do ever deny it, you've got them where you need them. So let's come back to that. But that is the case of REA if you ever need it, to tell you exactly what the law says on that. But that's where the Court of Appeal, sorry, the higher courts always stand with that matter. I've also included the case of REH, which I think is quite a useful case when you're for the local authority, because even though we're all lawyers and even though we're all too smart for our own good, I have fallen into the trap, as I'm sure many of you have, of social workers saying, I'm really worried about this and I'm really worried about that. And you sometimes start to not see the wood from the tree. And if you're a bit like me, sometimes you'll be like, oh, this is a huge concern, that's a huge concern, without thinking, hold on a minute, do we have the evidence for it? And so it's helpful, I think, to remind yourself and social care about this part of what REH says. A court's conclusions that the threshold conditions prescribed were satisfied must have a factual base. An alleged but unproven fact, serious or trivial, was not a fact for this purpose, nor was judicial suspicion. Now let's pause there and take that in turn. I've had cases where you have a father who we say is domestically abusive and has a history of violence. And then when you turn to the police records to try to evidence that, he's got markers for violence. Is markers for violence a fact? Or are markers for violence a fact? Anyone? Miss Foster, I can see you doing this. No, it isn't. Absolutely. Remember, a conviction is a fact. Markers are not a fact. And if you, when drafting, see certain records to say him having abused the previous partner and some specifics of an officer's note of what was said, if you want your primary evidence, you need to find that partner and gather a Children Act compliance statement. That is your primary evidence. Or for instance, if the officer saw some of it, that's your primary evidence. Get the officer to give you a statement. But be conscious of that, because I think it's very easy to see these things in police records and think, oh, that's my evidence. And actually, when it comes down to it, under REA, you would fall. The other thing is, though, and this is stylistic, just to give you all a tip, if you have, I don't know, 3 allegations that he's been violent that you've got primary evidence for, and 1 allegation that he's been violent that you've got hearsay evidence for, and you've tried your best to get a statement and you haven't been able to do it, where does that leave you with that 4th one? Well, if I'm honest, I would plead it. I would plead it on the basis that the court has to look at the tapestry of evidence as a whole in family proceedings, the wider canvas, and if we have 3 reliable primary evidence witnesses saying that, in fact, this is how he behaves, I would invite the court to give that hearsay evidence more weight than it would normally do, because it fits with his pattern of behavior. Does that make sense to everyone? So sometimes I would say you can craft, if you've only got a little bit of hearsay, you can craft it into a pattern of behavior and still rely on it. But generally, when you plead threshold, you're putting everything at its highest. And at that point, you've got to think, have I got the evidence? Do I need to go and get it? If so, I must get primary evidence. And if you can get some hearsay alongside to bolster your primary evidence, do it. That's fine. But obviously, the primary evidence must be the priority. So then the next part is what the next part of this says, what do we need to take from this? Well, is there evidence relied upon, primary evidence? Now, pausing there, you all know that threshold must be based on evidence. So that is the key part of it. If not, can we get primary evidence to speak to this? Can we evidence everything that we assert? Or is there suspicion pleaded? And that is where I think as lawyers, sometimes you have to go back to social care and say, this won't do. Because they may well want you to plead certain things that you just can't prove. In which case, as the lawyer drafting threshold, err on the side of caution with that. I'll tell you what I do. At the start of proceedings, obviously you have to put interim threshold in based on what you have. And I don't think anyone ever criticizes the local authority, or very rarely do you get criticized for doing that. But when you come to draft threshold later on and you look at all of the concerns, and I know you're not meant to use the word concerns, but we're local authority lawyers, so we'll use the word concerns. When you look at all your concerns and you plead them, if you think, no, I can't evidence that, no, I can't evidence that, I think my style is to put it at its highest and go and identify at that point who the witnesses are that you need and go and get the statements. That way, in the time that the parents will take to respond, the 2-3 weeks, you might have the evidence by the time they respond. Does that make sense, guys? Nod your head if you do, yeah? But drafting, when you're drafting, always think, have I got the evidence? If I don't, go and get it now. Go and get the statement from the person who saw it. Don't rely on markers in the police records. Don't rely on the odd bit of writing on a police piece of paper. That's not enough for an allegation. If the parents challenge the assertions, can we produce the witnesses? Well, let me talk to you about that in a minute. A good example of that is a case I have at the moment. Very, very basic case. It's not complicated at all. But when I picked it up, I was told the social worker's gone on leave, so her manager will be speaking to her assessment. Except then reading the assessment, it's not just about balancing. It's a lot of, Dad told me this. Mom told me this. Dad said these words which caused me concern. Mom said these words that caused me concern. If the social worker speaks to that assessment and is challenged and it's asserted, Mom never said that, well, what evidence can the social worker give to contradict that? But sorry, not the social worker, her manager. What evidence could her manager give to contradict, Mom never said that? Well, the answer is she can't, can she? Because she wasn't present at these assessment sessions where the social worker was told this. And so we have to be careful when we pick up cases like that, because quite understandably, the social worker went on maternity leave and there was nothing that could be done about that. But I think as the local authority lawyer, you need to advise your client department that if someone will be leaving, you need to keep the contact details, because if that evidence is challenged, we need to recall that worker, because they're the primary evidence. Sorry, they have the primary evidence, they were there. But B, if we know, for instance, someone is going on maternity leave and just simply won't be available, then what we need to do is we need to make sure that there's someone else that attends those sessions, so that if any of it is challenged in terms of what was said, that worker can come to speak to that. Does that make sense? Now, that is a bit easier when we're looking at welfare, and I appreciate that what we're talking about is threshold, and you tend to come in when it's a little too late. But for instance, if you're in the PLO process and you can spot a pregnant social worker, or you're told that a worker is going off for a year's break or something like that, that's your chance to flag to the client department to say, look, when we end up in court, the evidence you gather in this period, which is the period before we end up in court, or if we end up in court, I suppose we should say, because we all know the PLO process works so well. If we end up in court, your evidence will be needed here. If you're potentially going to go off shortly, have someone else attend, have someone else be there present to listen to what's said. So if your evidence is challenged, they can come and give evidence. And then, you know, when you draft threshold, I have primary evidence to back up what I'm drafting. So that's something to raise there and to think about. If not, is it proper to hold these matters against the parents? Well, 9 times out of 10 it is, but we have to follow the law, don't we? And the law says if we can't prove it, that it never happened. So sadly, if we can't evidence it, you will need to take it out of your threshold document. As I said, my style is to draft everything in when I do the threshold, then give the advice on what statements we would need and other bits of evidence. And when everything comes together later on in a few weeks' time or a month or whenever, if I realize that despite best endeavors, we don't have certain statements, then I take it out. But to start with, put it at its highest and try to get the evidence. That sometimes means, sadly, that I've had to advise local authorities to drop, for instance, sexual abuse allegations, rape allegations. And sadly, we work in a world where not everyone wants to come forward to talk about rape. Not everyone wants to give us the evidence we need in respect of those matters. And I'm sure you all know the binary system, that if we don't pursue it, we have to drop it. Now, I'm not saying that there aren't cases where you shouldn't pursue those matters based on hearsay evidence. There may well be. But the general rule is, if you have a case like that, you do your best to get the primary evidence. And if you don't have it, you should take stock as to if you have enough to keep going with that. Sadly, in a few of my cases, I've had to say, no, I don't think we do. And we've had to back down with those particular allegations. And have we linked everything said to our risks of harm? So have we just stopped the sentence at dad misuses marijuana? Or have we gone on to say this impacts on the family's budget, which means that at times the children have not been able to get everything that they need by way of milk, by way of clothes, and evidence that is the link to the risk of harm, to the neglect that they may suffer as a result of that. So those sentences, those sometimes add-on sentences, are important. So that's what we can take in terms of where we're at so far, in terms of the law and the evidence. Let's discuss then some matters stylistically that may come up. We've already discussed police statements in that they're not primary evidence, and if you're going to rely on what an officer says, you need to gather it. Now, I know that local authority solicitors have a lot to do. And of course, you all know that from an evidential perspective, we are the prosecutors. We have to gather the evidence. So when it comes to deciding which officer should give statements, I always take this approach. If all he did was rock up at the house, arrest Joe Bloggs, put him in handcuffs, and Joe Bloggs didn't say anything, do you need a Children Act statement to that effect? What does it add? Remember the relevance test, it doesn't really add anything. If, however, he's rocked up, he's spoken to the father, who then turns around and said, oh, you're arrested for touching this child. And he says something like, what, and not kissing as well? I thought you would have known about the kissing. You want a statement for that, if you see what I mean. So you cherry pick necessarily from the relevance test what you might need. But of course, as the local authority representative, don't forget that if there is something that undermines your case, so for instance, I recently had one where we were relying on text messages, and one of the officers turned around and said, when we looked at the text messages, actually they didn't support a rape conviction, and very much suggested that the complainant had consented to meeting this person for sex. You still have to gather that statement, because you have the duty as the local authority representative, or the local authority has the duty to put everything before the court. So just be conscious of that when you gather evidence to prove your threshold, that even if you come across something that looks as though it doesn't support your case, undermines it, the relevance test still says that you need to gather that evidence, even if it's not going to help your cause, sadly. Of course, it will form part of the wider picture of whether you pursue those matters, or whether you need, for instance, to reword it. So the example I specifically had was with respect to a 16-year-old girl, and she accused the father of raping her. And when we looked closer into the messages, it very much came across that she knew she was going to meet him for sexual intercourse. Now, that doesn't mean that she wasn't raped, but after she refused to come forward, we had to change the allegation that we would seek to litigate from one of rape to one of grooming. Still quite serious, but not necessarily what I would have wanted to go for. But sadly, we just didn't have the evidence for a rape without her coming to court to speak to it, especially when the messages and the officer's statements told us they knew that what they were meeting up for. And it wasn't as she put it, which is, oh, he jumped me in the forest. I had no idea he was going to be there. She knew who she was meeting and the purpose. So just be conscious of those things as you gather. Do we lose the sense in redactions, that should say? Again, I'm not written this very well, have I? Or should they be redacted? Now, again, I know sometimes there are concerns about making sure that information stays confidential. But of course, these are still private proceedings. And we should keep that in our mind when it comes to things like redactions. I know the police go crazy with redactions, but sometimes social care needs to be a bit more practical about what we put before the court. So for instance, if it's a name of a non-subject minor, use the initials. And then if it's going to be a hotly contentious issue, you may need to approach those minors' parents for permission for their name to be disclosed, because no doubt you'll all understand that if someone is accused of hurting a minor, abusing a minor, they need to know who's making the accusation against them. That's fair. So in that sense, redactions, we should be conscious of making sure that we give as much detail as we can. in a sensible way so that the other side can defend themselves. I also think sometimes some of the redactions are just not needed. So for instance, the police can redact things like grandmother's name when we know grandmother's name because it's in the social worker's initial statement. Do you see what I mean? And sometimes I raise this because they may not seek to they may not seek to unredact certain parts of their disclosure. But if you have an officer statement that is heavily redacted and you can more or less make sense as the local authority representative, that doesn't mean everyone else on the case can, but as the local authority representative, you can more or less fill in the blanks or make sense of this, or the social worker can, but no one else can. Please do fill in the blanks before you file it, as long as it's safe and it's appropriate to do so. Like I said, with Granny's name, I've had another example where we've had a non-subject child, but it was the older child of the respondent mother. So everyone knew the child's name anyway, because you put that in the initial social worker statement, wouldn't you? Mother has an older child called X. So then the whole point of redacting it was pointless. And when you come to gather these statements, please remember that the sense has to be there. If something's been redacted that doesn't need to be redacted, take it out. Don't redact it so heavily, so that everyone can understand what the allegation is and what's being properly said. Again, we've covered point 2, which is about the social worker leaving and making sure you keep contact details. That's as relevant for welfare hearings as it is for threshold. Is the evidence from anonymous referrals. Now let's talk about that a minute. How many people plead these really serious anonymous referrals that we get where they go, oh, we heard the child crying. So I'll give you an example. I had one recently with a case where we ended up issuing on the back of the neighbor turning around and saying, I heard the child crying, I heard slap marks, I heard the child saying, no, daddy, no. We issue the proceedings, quite proper to rely on it for interim threshold. But then when we had our medical reports and such, there's neglect, so we still have threshold, but there's nothing to suggest sexual or physical abuse. Other than going to the neighbor and getting a proper Children Act statement where they say, my name is so-and-so, because the other side need to know who's making the allegation against them. I heard X, Y, Z. An anonymous referral is it doesn't carry any weight, really. I was going to say it's hearsay and the court can give what weight it wants to it, but I think the reality is the court would probably go, I can't give any weight to this. So I always think with anonymous referrals, if you see one and you think it either supports part of a wider allegation, or stands an allegation on its own, you want to get the statement or approach them for a statement. Not every neighbor will give one, not every family member will give one, but you have to approach them. And then you know, as the local authority solicitor, when it comes to evidencing your threshold and putting the case of social care at its highest, you've done your best to do that. Is the evidence of violence based on markers versus convictions? Well, we've covered that. If it is evidence from a child witness, how is it recorded? Now, I did another session on taking allegations from children. Just by way of brief reminder, obviously we need to make sure that the evidence is captured in a reliable way, so a child not being led into saying certain things, and we also need to make sure that there are contemporaneous notes, and wherever possible we need to be pushing for ABE interviews. If none of that is available, and all we have is, so for instance, a family support worker statement saying, the child once told me daddy hit me, well, that's not going to do. We need to know, do they have contemporaneous notes? What date did the child say that? What were the circumstances? Who was present? How did that conversation get introduced? And you will need to, as the lawyer, go, is this reliable evidence? Do we need to go back and get a more clear, detailed statement? Now, I know you're all thinking, gosh, she's just lecturing us about the quality of evidence, but that is important when it comes to drafting threshold, because you are ultimately the person who will have to decide what stays in threshold and what needs to go. And that's why I'm lecturing you on evidence and strength of evidence, because that very much affects how we draft threshold. And here we have, what if you don't have the evidence? Well, if you don't have the evidence, that's the end, isn't it? We might have a particular concern, but again, concerns, the court doesn't work with concerns, it works with risks of harm to children that can be properly evidenced. And sometimes, sadly, if we don't explore the steps we've just identified above to try to get the primary evidence that we need, then we struggle. Can hearsay alone be relied upon? Well, I would say as a general rule, no. But of course, you have the odd cases. Like I said, if you've got four people making the same allegation, and then a fifth person comes in and makes it, but that fifth person you can't get a statement from, you might be able to prove that based on hearsay because the primary evidence is so strong in showing a pattern. But as a general rule, hearsay is not to be relied upon in that way. I certainly think the court doesn't let you do it with very serious allegations in particular. So for instance, sexual abuse matters. Let me ask you this. If you have, like I do, I've got a case where I've got a dad who has been accused by two nieces of sexual touching, and they've given ABE interviews to the police. The counsel before me pleaded that as part of threshold, but that was the end of it. And I don't know if any of you know her, on Judge Troy in New York. She was not particularly impressed, and that was the extent of the local authority's case. What do you think the local authority had done wrong? So the extent of it was pleaded in threshold on the basis of the ABE interviews that formed part of the police disclosure. No one? Okay, shall I tell you the answer? Not if you want the answer. Yes. So what they've done wrong is this. It's all right to rely on an ABE interview, but of course you will all appreciate that an ABE interview is still hearsay evidence, isn't it? An out-of-court statement that goes to prove the truth of what it says. So it's still hearsay evidence. And what the local authority needed to do was, if you were going to rely on what someone said in an ABE interview like that, so for instance, a non-subject child or an adult who is not a party to proceedings, then that person needs to be formally brought in as a local authority witness, which involves gathering a Children Act statement, because that's how we turn it from hearsay into primary evidence, that says, my name is so-and-so, I have considered my ABE interview, I stand by my allegations made therein as accurate, I am willing to attend court to give evidence in support of this. So that's a one-page Children Act statement, but it does exactly what we need, which is turning the hearsay evidence into primary evidence. Does that make sense to everyone? Yeah. So always remember, if you're going to rely on something, just turn it into a Children Act statement. And sometimes it's as simple as that. Another example is if you have a police statement that doesn't have redaction, so you don't need to retype the whole thing, just get a statement to say, my name is so-and-so, I've read my police statement, I exhibit it here to this statement, I stand by it as being accurate, and I'm willing to attend court to give evidence if required. And that's a Children Act statement that then turns that police statement from hearsay into primary evidence, and you can rely on it in your threshold document. So yes, so that is in terms of evidence and how you start to think about threshold when you draft, around what you need to prove, how do you get there to prove it. So let's turn about what you would actually write in threshold, because I think that's probably what you all want to know anyway. Structuring threshold, and my first point is, let's talk style. Is it so everyone has a different way of drafting threshold, but I take this view with it. The easiest and simplest way to link the risk of harm to the child and to make that very clear to the court is to use headings. So for any of you that have instructed me, you see headings like neglect, emotional harm, physical harm, sexual harm down my threshold documents. And then everyone exactly knows what type of harm and what nature of harm you're pleading. And then is it clear with headings? Well, yes, I think it is. And it addresses the point made by Baroness Hale, or Lady Justice Hale at the time, link it to the nature of harm. Do we need examples to justify what we say? So sometimes, and I'm sure we've all come across this, you've got, for instance, father has sexually abused the child. No, that's a bad example. Let's go for physical harm. Mother has physically abused the children. Now, that isn't the allegation, but of course, if mom denies that, you need to prove it. But you're not going to litigate the 300 different times the child has said, mommy's done this, this, and this. Because, of course, what they say may be something that's happened for many years. I have a case at the moment where the abuse has started basically from the birth of one of the children, and the child is now 14, 15. So they keep giving out these little nuggets of incidents that they can remember, as I'm sure you can all understand. But I'm not going to plead absolutely every incident. So this is what I do. I put a big heading, physical abuse or physical harm. The respondent mother has physically chastised the daughter, let's call her, make up a name, Sally. And I put instances of this include. So don't just say it has happened on X and Y's occasion, because it's a pattern of behavior you're establishing, or examples of this are pleaded below. So then the whole pattern is still there. Or you might say the respondent mother has physically chastised Sally from the age of 2 until 15. Instances of this include, and then when you come to draft, this is the stylistic element. You need to make sure that no one stands up in court and goes, why are we going back from when this child is 2? Right, that's what you need to avoid, right? But of course, she's been saying it since 2. So how do you avoid that? Stylistically, this is how you plead the youngest allegation, the very first one that the child makes. Yeah. So if anyone then goes, well, why are you pleading? Why are you exploring that in cross-examination? Or why is a local authority thinking we'll go through this whole family's history? You can go, because it's relevant to one of the allegations on the table. Then you plead one, I'd say 3 or 4 years after that. Then you plead one 3 or 4 years after that. Then you plead one 3 or 4 years after that. And then you plead the fact that the one more recent or 2 more recent. The reason I do it like that is this. As counsel, when you will run this case in court, I would be very, very bad at my job if all I did was go in and say, you've abused a child, you've done this, you've done that, you've done that. And actually what I need to do is what the court needs to analyze, which is a holistic analysis of the case and go back to when this child was born, what were the circumstances around that, what were the pressures on the mother, what was this child exposed to, therefore the child's been hit. A few years down the line, what was the home family life like? Which fathers were in the scene if there's more than one? What were the pressures on her? What was her mental health like? Allegation 2. A few years after that, what was the situation like? What were they doing? What was this child's behavior like now that this child was a bit older? Allegation 3. And by doing that, I will evidence to the court that there is a pattern of behavior over many years because of the circumstances of the family, which means that what the child is saying may be true here, may well carry some weight. So that's why, from a stylistic perspective, if you ever see something that has to say, and I think, in fact, I dealt with it at the 4th bullet point down, establishing a pattern of behavior. What if something happens over several years? You want to put your examples like that, cover them in a years so that you can litigate and explore the full package. Always put examples for things you say, because if mom denies it, you need to point your finger. So if I say neglect, the home surroundings, the home environment has been very neglectful, which has placed these children at risk of physical harm and brought instability into their life. I will say, for example, on X date, bam, the home was like this. On Y date, bam, the home was like this. And I always make sure that I use 2 or 3 examples under every heading so that even if they deny 1 and accept 2, you've got your threshold. Even if they turn around and say, no, that's a lie, you've got specific instances that you can refer to primary evidence to take them down. And that's the reason you do it like that. Can I just say there, though, just be careful of this. The home conditions were neglectful. On the 5th of June, the social worker says that the home was this, this, and this. Could someone see something that's wrong like that, with that? No? Okay, so there's a difference between what you're trying to prove. Are you trying to prove that the social worker said it, or that was what it was? Do you see what I mean? So if you litigate, if you plead, the social worker says that the home was dirty, well, who cares what the social worker says? That's not threshold. What's threshold is the home was dirty. So your allegation is not the social worker says. Your allegation is on the 5th of June, the home was dirty. Does that make sense to everyone? Yeah, because we're not disputing that the social worker said it, which is how the first version puts it. So again, it's, I've seen thresholds that say, on the 7th of June, the officers visited the home and took the view that the home conditions were unacceptable. Well, I don't care what view the officers took. That's not what I'm litigating. My threshold is on the 7th of June, the home was in an unacceptable condition. And then where you find that evidence, you put the page number that the officer says it was. That's your evidence. But that isn't the threshold point. It's not what the officer says. It's what actually it was. So just be conscious of that from a stylistic perspective. Again, that's why next point, are evidential references important? Yes, they are. We know that they are. And in fact, good drafting of threshold must always, at the end of every allegation, reference the page number that you say supports this evidentially. That's really important because anyone that's instructed me knows I like to go to town on threshold. I don't like to let parents off on anything. So my threshold documents are 4 or 5 pages long, and I don't care. They're going down. But I make sure that every sentence, every allegation, every paragraph is properly evidentially referenced, because then from during the proceedings, parents are more likely to accept it because their representatives can take them straight to the page and go, oh, well, the police officer said this. Do you see what I mean? And B, there's no argument in court. Oh, you haven't got the evidence to prove what you're saying. And C, you know how strong your case is if everything you assert you can link to the page of evidence, because as you're drafting you'll go, that isn't very good, I need to bolster that. That isn't very good, I need to bolster that. That isn't very good, I need to get the primary evidence. So it's to your benefit, it's to the court's benefit, and it's to everyone's and the parents' benefit if you do that throughout. That is the way you're meant to draft threshold. You're meant to link it to every bit of evidence that you rely upon. And if you don't, you can get pulled up on in court for that. That is actually what you're meant to do, according to Lady Justice Hale. So there's that element as well, which is the evidential references. And then finally, how do we word an allegation? And we've covered that, the she says versus she did. And that is where the second section of REA comes in, and I've put there. And you'll see the last part is the relevant allegation is not that he appears to have lied or X reports. The relevant allegation is that if there is evidence to support it, it is surely that he lied. He did Y. So it's not about what people are saying, the impression they're forming, it's what actually happened. That's the most important. And just be conscious of that when you're drafting. Again, the second part of that judgment that I've highlighted lacks honesty with professionals. The reason I highlighted that part is I'm sure you've all come across this, where you've got these really, I'm trying to think of the most professional word I can use to describe them, but these really difficult parents who do lie a lot, who do just not engage with social care and don't like social care. But the argument will always be, well, so what? Where is the risk of harm? How have the children suffered? And I'm sure you're all aware that dishonesty in itself is not enough. I'm sure we all know that. So for instance, I had a case where we had a huge fact find and found a 5-page threshold document. But fast forward 6 months when we got to welfare, both the social worker and the guardian in their analysis of the welfare checklist relied upon the fact that the parents were dishonest at the time, and the parents are still being dishonest about what really took place in the home. They're not accepting the findings of the court. And the judge quite rightly pointed out, even though she was the one that made all of the findings against them and clearly didn't want these children going home, she quite rightly pointed out to both my team and the guardian's team, I get where you're coming from, but so what? Because there's nothing on the table in the last 6 months to show that they've harmed these children or they continue to lead a harmful life. So we need to rethink the issue of honesty and if that is enough. And you need to always advise your department. Honesty might be a reason to look at, can the risks be managed, but you still need to identify the risks in the first place. Dishonesty is not enough to plead in a threshold document. So the way I always do it, just from a stylistic perspective, is I'll plead the risk of harm. You know, the home conditions have been dirty, the children have suffered physical harm, they've suffered emotional harm because they've been bullied at school, they've suffered instability because they haven't had a stable home or a stable bed to sleep in or a stable kitchen to make their meals. And what I'll put is a second paragraph to say, when social care have tried to mitigate these risks, the parents have been dishonest and misled about the true condition of the home as per blah, blah, blah. This means that the children are further placed at risk of harm. So that's how I tie into this honesty. It's never just on its own, the parents are dishonest. It's linked in with the risk of harm. And always remember that. I have a case at the moment, quite a big case, and I think Kate is on this line, knows the one I will refer to, where we have a particular parent who's incredibly dishonest. When I came to drafting threshold, it was a mission, because I could have sat there and just pleaded dishonesty all the way through, but I had to remind myself that dishonesty in itself isn't enough, and I have to link it to different risks of harm, otherwise it doesn't work. And I can say that that was a mission to do. I managed 5 pages, don't get me wrong, I'm not losing my style just yet. I managed 5 pages of harm, but it was difficult to do that. And that's something that if you have dishonest parents, you have to be very conscious of. Link it to a risk of harm, because if you can't, it's going to fall through. It just won't stand up. Okay, guys, let's turn over then the final document. And I'm doing well on time because we're almost done. So final threshold then. Remember your overall headings: emotional harm, physical harm, sexual harm, neglect. Is there a pattern of behavior to be established over several years? And remember what I said, go through the different years so that when you cross-examine, you've got it all there. Is it properly evidenced? Well, you would have taken your time at this point to properly gather the evidence as you were drafting throughout. So in theory, you've got all your primary statements and all your Children Act statements, and you're ready to take these parents down, because let's face facts, that's what we need to do. Does it plead facts or assertion? So the social worker says versus the home is dirty. And we need to be very conscious of that. And is it clear? Well, if you've done it in this way that I suggest, then it should be clear, because what you've done is, to make it even clearer if you need it, is to throw in a line at the bottom just around harm. So let me give you an example of that. I've got a sex abuse case at the moment. And there's so many allegations of grooming and rape and all the rest of it. They can really get lost in it when you plead it. I think I've got about 2.5 pages of everyone that this man's touched. You know, one of these over-friendly dads that just goes around touching people. He's one of those, right? I'm sure we've all had those cases. And pleading it was fine. He's groomed this child. He's done that. He's done that. But when it came to linking it to harm, I would be writing 2 sentences in every paragraph going, therefore he's a risk of harm, therefore he's a risk of harm, therefore he's a risk of harm. So what I did to make sure I didn't forget and it was there, but also to show that it was there and to not make the document 10 pages, was at the end I put a paragraph that actually says, as a result of the actions of, I don't know, let's call him Mr. Smith. Mr. Smith, as described at paragraphs 1 to 9, Mr. Smith poses a risk of sexual harm to these children. Does that make sense? So sometimes if it gets too convoluted, just link it at the end. Just make sure you keep that risk of harm in your mind, that that's what you're linking back to. That's what you're linking back to. And are there relevant and powerful examples, which I'm sure you all understand that if you haven't got the right evidence for it, don't rely on it. Or if, for instance, there's a slap or there's a broken bone, you might want to go for the broken bone, obviously. So it's the relevant and powerful examples. If you can manage both, by the way, go for both. Like I said, take the parents down. Interim threshold, well, it's the same principle. Overall headings, but obviously, if you cannot yet plead facts, can we plead assertions? And what I mean by that is, I think you get some leeway with interim threshold on this. I've seen many solicitors write things like, as a result of Child A making an allegation, the police have exercised their powers of protection and the children are currently, the parents are under bail conditions, which mean that they cannot care for the children. That is a completely valid interim threshold point. And so that's why sometimes you do your best at the start to plead facts, but that is still threshold. That is still a threshold point. So you can still plead assertions early on. Do we have primary evidence? Well, if you don't, gather it. Interim threshold drafting is your first chance to spot what you might be missing. Is it clear? Which of course you'll all go for. And again, relevant and powerful examples. Now let's look at an example in our last couple of minutes, just so you understand what I mean, because all we've done is talk theory. So let's talk practice. How not to draft, I've called that. Michael has said that his father's hit him twice. He also said that his mother has touched his bit and laughs at him when he cries. Julia had marks on her body last year. She smells of cat urine. Father and mother have been spoken to and have not done anything about this. Can someone tell me what they think is wrong? Don't look at the good example yet, by the way. Can someone tell me what they think is wrong with how that is drafted? Anyone? I'll pick someone if you don't.
It's all Michael says, she says, it's all reported.
Yeah, that's the first thing that's wrong. Michael said, yep, go on. Second thing, let's stick to the first sentence. Said that his father has hit him twice. If you read that, the first thing I think is when, where. Do you see what I mean? None of that's there, is it? Right? No precision. Remember, is it clear? No. He has also said, again, Claire's point, it's all what he said, that his mother has touched his bit and laughs at him when he cries. When did she touch his bit? What did he say? Who did he say it to? Is there anything more we can do then? Right? And laughs at him when he cries. Well, isn't that emotional harm? If you're going to plead that, I mean, if you're going to plead that, isn't it emotional harm? Yeah, but it's tied into a sentence to do with sexual harm, which is in the same paragraph as a sentence to do with physical harm. Can you see what I mean? Yeah. And then at the end of that, there's still nothing that says, therefore, the child has suffered harm, which is the follow-on sentence that you need, really. Then we go straight in, no headings. Julia has had marks on her body last year. Is that clear? What kind of marks? Dirt marks or bruising? We don't know, do we? Where on her body? Goodness knows. She smells of cat urine. Well, that's a bit clear. But again, when, what circumstances? Mother and father have been spoken to by who, when, what were they told, and have not done anything about this. Yeah? And why is that relevant in linking into the overall picture of threshold? So watch me take 2 sentences and break, this is why I end up with 5-page threshold documents, by the way, and break this down into a full page of threshold, right? Let's look at the first one. In or around June 2020, Michael was hit by his father. This occurred on 2 occasions where he was slapped across the face on both occasions. This has caused him both physical and emotional harm and places him at risk of harm moving forward. And your evidential reference is C4. Can you see how that first sentence becomes a lot clearer if you spell it out like that? There's no way that someone doesn't know what they're being accused of. Second one, Julia, and by the way, look at my headings, physical harm as a heading. Julia has also been physically abused by her parents, father or mother or both, which has resulted in her suffering bruising to her body on or around June 2020. Now, if you can narrow that down more, you know, that at this stage, her bruising is on her thigh, is on her face, it's resulted from a slap mark. Depending on what the expert report says, then you'll plead that. But I was thinking more with that one, say your initial threshold, where all you've got is it's happened on a certain day, one or both parents have done it, and it's on the body, and you don't even know yet because the social worker's still not sent you the initial statement, which part of the body. Do you see what I mean, guys? Yeah? So then we move on to sexual abuse. Michael has been sexually abused by his mother. Michael's mother has touched his penis sexually on 1 occasion. That's the bits. We've clarified now what that is. He has therefore suffered sexual harm and is at risk of sexual harm should he remain in her care, and an evidential reference as to where we get that from. Yeah? Turn over the page. Link it to Julia. Julia is at risk of sexual harm as a result of her mother's inappropriate behaviors with Michael, as identified in paragraph 2 above. Yeah? Otherwise, we would have lost that. We would have lost the element of Julia is also at risk. Then we go to emotional harm. The respondent parents have not responded appropriately to Michael's needs, which has caused him further emotional harm. That's a general sentence, so give your example. For instance, on the 13th of August, when Michael has been emotionally upset and crying, his mother responded by laughing at him. This was, it should say, emotionally hurtful and confusing to Michael. And then finally, neglect. Julia's personal care has been neglected. In particular, her parents have not taken care of her personal hygiene, and the result is that she has smelt of urine when she attended school on the 23rd of June and the 26th. This has physically harmed her and placed at risk of emotional harm due to the risk of being bullied. Can you see how I'm linking it at the end with the harm, the nature of the harm in absolutely every sentence? On the 24th of June, the respondent parents were informed of the issue of Julia's smell and advised of the importance of her washing before attending school. So we know exactly what they were told. Notwithstanding this, they did nothing to resolve the issue, and Julia later presented at school in the same condition. The parents therefore continued to place Julia at risk of harm and not adequately meet her needs, that should have said. Okay, guys, so can you see how 2 sentences that are really confusing and convoluted can be broken down into my 5-page threshold documents? But you've covered everything. You've accused them, you've given them the date, you've given them the exact circumstances, you've evidentially referenced it, and you've linked it to the nature of harm. Does that make sense to everyone? Yeah? Do you all understand stylistically why you might take certain ways of phrasing things or certain examples that you might use? Do we all understand why, as we draft, we have to review the evidence and make sure we have the strongest evidence that we have? Have I bored you all senseless? No, of course not. Okay, then, that is the end. 1402, so I just covered it. I hope that was helpful to you. Please, by all means, drop me a line, email me any questions you've got, and hopefully I'll see you guys at the next one. Take care now. Bye.